Hello and welcome to David Starkey Talks. Last week on this programme we heard from the Deputy Leader of Reform, Richard Tice, on his backing for the legal action to thwart the government's surrender of the Chagos Islands. Well, the first hearing of that legal action has taken place, and it's revealed, well, not, as it were, a government that's lily-white legally, and who thought it would, but it's revealed some of the tricks that and I use that word deliberately, that the government is using to ensure that the takeover of this British sovereign territory, in other words, the equivalent of the Falkland Islands, goes ahead. And I'm very pleased to be joined by James Tunbridge, who is a barrister who is representing the Chagossians who are taking this action. These are the people, aren't they, James, that we've heard really very little from and have barely figured it at all in the government's presentation of its case for obvious reasons. Quickly, who are they and what is their standing in the case?
Well, it's a pleasure to join you, and that is indeed where we need to start. It's a terribly tragic tale, and what I'm concerned about is that since the 1970s we've had many cases and many government statements about how badly we've treated the Chagosians, but we never actually make things right.
Quickly, the Chagosians are the people who were on the islands before they were cleared off to make way for the Diogasia base. That's broadly it, isn't it?
Well, yes. I mean, the islands were first settled by the French with a number of people from Africa. In about 1840, they became British, and from 1840 till roughly 1973, several thousand people lived on those islands, largely subsistent farming. And they are who we call the Chagosians. We say they're a clear ethnic people.
Oh, can we use words like that?
Well, yes, and I've put it to the government.
Well, apparently I can't call myself English. It's nice that this group of people who've been recently assembled from miscellaneous origins and shoved on a semi-unknown archipelago in the middle of the ocean.
Now you sound like you're arguing for the government. That's their view. Our view is that it was the Labour government of Harold Wilson that did this deal and decided that to have this military base, all the islands had to be depopulated, and these poor people were thrown around the world. Quite a lot of them ended up in Mauritius, although it should be noted that the closest landmass is India. I mean, Africa is nearly 2,000 miles away.
No, it's in the middle of the Pacific.
Yes. Indian Ocean.
But the Indian Ocean, yes.
So they are a clear group of people that lived on the islands, and they've all been kicked off. They've been treated very poorly. They've ended up in poverty, and they have tried many times to have their nationhood and existence recognised. They have regularly asked for consultation when decisions are taken. Now, when David Cameron was Prime Minister, he did start consulting them. There's a huge marine reservation around the islands, and they were asked about that. A central tenet of the case that I'm bringing, because I'm bringing a case on behalf of them, I can't challenge the treaty or Parliament. I'm saying, why are they being ignored? Because they were consulted over marine reservations, but they were not consulted over the giving away of their homeland.
Can we just again be clear, and then people will, I hope, grasp more fully what we're talking about? We are talking about a group of people. How many thousand, roughly?
Roughly 8,000.
Roughly 8,000. In other words, we're talking about a situation strikingly analogous to what went on in 18th century Scotland and 19th century Scotland and is dramatised and romanticised as the Highland clearances. It became appropriate for economic or strategic or political reasons simply to move a group of people, like so many cattle, from one place to another. That's what we did. That's what a Labour government did in order that it could set up a military base.
Yes.
That's effectively the summary, isn't it?
Yes.
And what you're trying to do is to use, I take it, human rights legislation primarily. Is that it? To get them a hearing?
Well, I don't want to be too boring on the lawyer front. We've got 6 key arguments. 2 of them are human rights related. And the key issue there is that the Human Rights Act and the Convention applies to the UK and British citizens. It does not apply to the islands. But our point is that quite a lot of these people are now British citizens. They live in the UK. Their rights are being affected by decisions in Whitehall. And we say it makes that relevant. The government doesn't agree with us because, of course, if we're right, they may lose.
So what we're really saying is, normally, if you look at the behaviour of a government of lefty Labour lawyers, soaked from top to bottom, from the Prime Minister downwards, in the importance of two things: human rights legislation on the one hand, and ideas of national self-determination on the other, you would expect this government to be falling over itself to reverse the, wouldn't you?
Yes.
Forgetting the fact there's a military base, forgetting the fact that they seem to have decided it's convenient, effectively, to give it back. Well, in fact, it was never Mauritius, but to give it to Mauritius as some kind of equivocation between Britain and between America and China and whatever. But if we were ever to take the kind of general observations they make seriously about human rights, about self-determination, they would be the hottest defenders of the Chagossians, wouldn't they?
Well, you'd think so, and actually self-determination is a great point to pick up on. Although I must be a boring lawyer for a second and repeat again, I'm not challenging the treaty or the bill. I can only represent the people. And in this conversation, I'm giving you the legal, but a bit of my own viewpoint, which is not the legal point. But the government in 2012, the British government, said that the UK is committed to self-determination in relation to the Chagosians. Well, they're not anymore. And it's an interesting view on race, actually, that the Chagosian people are dark-skinned, Christian, Creole speaking. Mauritius is majoritively of Indian origin, and there is a lot of tension. There is a history, a documented history of the poor treatment of the Chagosians in Mauritius. So I do wonder, why does the Mauritius claim matter, but the rights of the Chagosians does not?
Well, indeed, can we perhaps work out some of the reasons why it might? Of course, what we're also dealing with here is potentially, at any rate, a clash of two separate schools or types of law: international law on the one hand, which in one construction of it has given the verdict of the International Court of Justice, has given, as I understand it, or rather has endorsed the claim of Mauritius to the Chagos Islands, as against what you've described, what I've tried to discuss and illustrate, the human rights self-determination claim of the Chagosian Islanders. But can we just explore perhaps a little of why this government might be so terribly sympathetic to the claims of Mauritius? I needn't tell you that the whole relationship of the various branches of law to common law was transformed by a certain man called Tom Bingham.
Yes.
In the extraordinary book that he wrote on the rule of law. It is Bingham who declares that the whole of international law is automatically incorporated into common law. Or more, I'm putting it in simple, fairly simple and straightforward.
Yes, I mean, so you've touched upon a bit of a lightning rod with me. I find it rather frustrating that in the desire of mainstream media to simplify things, that they talk constantly of international law, and it's become a totem, particularly with some politicians, to say, "Oh, international law." I mean, we've heard,
and we've got a duty to maintain it.
Exactly.
We were one of those who
Yes.
set up the rules-based system of international order. Britain's reputation depends on it. Our reputation for good, straightforward dealing, the fact that we're a major centre of international jurisprudence, all of that stuff, right?
Yes.
Yeah. And it's stuff, isn't it?
Well, it is, but these words really mean something, and one has to break them down. And let's just start with international law. There is no such thing in one sense, because when we talk of, say, English law, it's derived from Parliament and case law. It's clear, we know where the law comes from.
There is an actual authority.
Yes.
In other words, there is, if you like, a sovereign source of that authority. And the problem with international law is there is no international government. So
Correct.
there is no single source of authority. And this is the problem. But I would argue exactly the same thing applies to a notion of international human rights law, or or European human rights law.
Well, we may be in alignment, but you see, the way I think it's better to think about this is international law is a series of contracts. It's two different states coming together and agreeing something. And so long as they agree to take part, there is a treaty, there is an agreement, that is a form of international law because two international entities have said that's what they will do. But there is no supra global body that gives us anything. It's entirely transactional. And we've got very old treaties, like the oldest alliance in the world is between the United Kingdom and Portugal. And you've got much more modern things, the various decisions at COP summits and so on. So this very simplistic, we have international law, is absolute bunkum. What we have are agreements that at a relevant time we are willing to be a part of.
But that is certainly not how it is presented by this government.
Well, it suits this government.
Well, no, I think, I mean, that let us be quite clear, and let us again go back and explore why this government, or one of the fundamental reasons it takes such a divergent line on this. We mentioned already the remarkably influential, but I would argue very dangerous book by Tom Bingham, arguing for the incorporation of this dubious entity called international law. Are you aware? I expect you are, James. Who wrote Bingham's gigantic obituary in The Guardian?
You know, I'm afraid I don't. I remember reading it, but I can't recall who wrote it.
Well, I think you'll find it very interesting. It's a certain gentleman called Philip Sands.
Oh.
Oh, he says. Philip Sands was, of course, the counsel for Mauritius before the International Court of Justice. He is the one, you remember, I think, videos himself after that verdict, pulling down the Union Jack.
Yes.
Can we be quite clear that there is we've already mentioned Harold Wilson, the man who is responsible for the Highland clearances of the Chagossians. Wilson also has that other phrase, a close-knit group of politically motivated men. There is such a group in the legal profession. Sands is one of them. Lord Hermer, who is the man who gives, interestingly enough, where is the government? Again, I'm now quizzing you. Where is the government's clearest statement of its absolute commitment to the most extensively defined view of international law? Who gives it and where's it given?
We had this statement from Hermer a few months ago.
We did. Lord Hermer. And what was the occasion that he gave it?
Oh, well, no, I wasn't expecting this particular memory test. Am I?
No, there we are. You see, isn't it wonderful? You're now in the witness box.
Yes. Well, I remember him saying it, but I don't know where he was.
Let me cut it short, because again, it's one of these things that will produce an "oh" from you. It was the Bingham lecture at Cambridge.
How very interesting.
You see, isn't it? So I think that this is all part and parcel of an intensely political view of law, which is disguised as simply general obligation to obey law.
Well, I'm certainly moving slightly away from sort of commenting as a representative of a particular group. I mean, I was in conversations yesterday on justice. It's the 800th anniversary this year of the reissued Magna Carta and the 10th anniversary of various UN sustainability legal aims. And people don't always understand just how significant the second Blair administration was on constitutional legal reform, because there were very significant changes. In fact, it impacted the Chagosians because the one time they had a bit of success was around about 2000. The constitutional order that controlled the law of the islands didn't actually preclude them going for visits, and they started to want to visit. And the Labour government under Blair didn't like that, so they issued a new constitutional law in 2004, absolutely killing their rights of abode and resettlement. They are supposedly allowed to have visitation for visiting family graves and so on. The government said that would restart. I have been trying on behalf of my clients to allow them to visit. The government has initially not responded, took 3 weeks to answer me, and then said, oh, it's really for Mauritius now, but we haven't handed the islands over. So I think it's quite shocking. The British government is already saying that before we hand them over, you can't even ask the British government for things that they're responsible for.
I mean, normally, this is also when you get this, clear, genuine legal uncertainty. It seems to me that there's profound, but there are profound questions as to what is the status of these various laws? Do they properly apply and whatever? I mean, wouldn't you expect judicial review culminating in the Supreme Court?
Well, you're now bringing me back to a very interesting place. So we had a hearing on Tuesday. It's called a permission hearing, and effectively, judicial review is a little bit unusual that you get to this stage, sort of six gateways before you get to a main hearing. This is gateway number 5. We need the judge to give us permission to have a full week, really getting into the detail on everything and forcing the government to candidly disclose how they've made decisions, because at the moment they're not doing so. Um, but we've got what's called a reserved judgment. I don't know whether we've won or lost. There's sadly a high probability that the reason the judge is reserving is to spend a week writing up reasons why we can't have our hearing looking at the government's decisions. Technically, if that happens, we have the right to go to the Court of Appeal, but we are representing principally pro bono these individuals, but there are court fees and other costs, and we've run out of money, and the government knows that. We've been asking for what's called a cost capping order so that we could afford to bring this case for these people, and the government won't do it. And it's a tactical decision, I'm sure. They know that if we don't have that protection, the lovely gentleman I represent who's a bus driver and his father who's retired, they can't afford to run the risk of going to the Court of Appeal and not being able to pay the legal bill.
So, in other words, as we're seeing in so many other areas, the government is actually using process as penalty, isn't it?
Yes.
It's using. We see it in everything from the non-crime hate incidents, the processes of arrest and bailing, and there's a government. What I find so striking, James, and what I find so really deeply disturbing, is this is a government that professes extreme devotion to law.
Yes.
But on the other hand, it is prepared to use, I use the word tricks, it's prepared to use every trick and indeed every dirty trick in the lawyer's book to win its case. And there's something deeply awkward about this, isn't there?
As a layman, you may well call it dirty tricks. I mean, I don't criticize my opponents for just being good lawyers and using what's at their disposal. But what I do think is interesting is when you've got a government that says it really cares about people, it really cares about minorities, it really cares about the rule of law, why are they so afraid of letting us have a few days in court to really ventilate these issues? Let our clients, the people affected, have their day in court and see what the outcome is. Clearly, they're concerned that if we do, they might not like the outcome, and that's why they're trying to close us down. Whereas if they truly believed what you've just described, the rule of law, the rights of individuals, why wouldn't they want to follow their mantra of respecting the law?
But of course you're right. But then look, this surely is a government, it's Israeli, who back in the 1830s describes my own particular party, and possibly even yours at one point, as in other words, the Conservatives, as an organized hypocrisy. But what we've seen now is this is a government of ultimate hypocrisy. I mean, look at the whole business of the number of property scandals that it's had, from the minister responsible for rental rights actually actually expelling tenants so that you could illegally jack up the rent, to the current extraordinary behaviour of Rachel Reeves over a house in Dulwich. Again, it's a government which, of course, is actually very, very prosperous people who are pretending to be working class people and, as it were, at the receiving end of the law rather than the giving end of the law. And surely exactly the same is here. The government's deployment of human rights law in Britain is surely just as cynical. And I'm going to use this word. I'm asking you now, not as a lawyer, but as a citizen. It's demonstrated just general cynicism, hasn't it? I mean, its approach, for example, to the grooming gangs is one of manifest cynicism.
Well, there are many things covered in your observations there. Where I would start is that as a citizen, I think that one of the things that the government really needs to be paying attention to, indeed the political class needs to, is that when the people feel that the law is something dished out to them that is unfair, they cease to have faith in it. They need to know
Absolutely.
that the law serves them. And actually, what you bring to mind is 3 or 4 historical and recent legal points. I mean, Magna Carta started out as the barons saying to the king, "We've had enough," and it was reissued a number of times, and successive monarchs used it to ensure that they weren't deposed and replaced with French monarchs and so on. And then, we've had various important steps forward, Glorious Revolution and so on. But what we've had in the last 20 years is a development of the law to achieve all sorts of things that politically were difficult. Writing into company legislation duties in relation to equality or the environment is something that people weren't paying close attention to, but they.
In other words, rather than the idea of law, which you and I and every other sensible person thinks of adjudicating either in civil law between the rights of individuals or in criminal law as to whether somebody has or has not committed a crime, we now have law that is actually designed to bring about social and political purposes. So what we've done, we've deadly introduced politics into law in a way which I think is deeply damaging to both of them.
Well, I think that's very true, and the really significant change was 2005. And in fact, I was part of a lecture and debate with a lot of well-known lawyers and retired judges and others last night, and I was trying to get them to be much clearer because people were conflating the independence of the judiciary and the concept of separation of powers. People bandy around separation of powers as if it's the panacea. They forget the United States is a young country, much younger than England, and it decided to separate the judiciary from the government because that was how it wanted to protect judges. But it's also why, to make judges accountable, they have elected judges, which we don't tend to appreciate as an idea here. That's not, up until 2005, how we operated. Parliament was all. The Commons and the Lords assembled, and that's why the most significant and senior court, when I was first in practice, was known as the House of Lords. It was the Judicial Committee. And the point was that the most senior decisions had to have legitimacy and accountability to the people. And Blair chose to make a number of constitutional changes. And the setting up of the Supreme Court wasn't simply a nice purpose building for them to sit in. It has profound influence on the judicial view and interrelationship with the political environment. And it's not that we didn't have independent judges before 2005. It's not that we didn't occasionally have judges that struck down laws. In 1995, John Major was trying to stop Spanish fishermen overfishing around British waters under EU law, and that was contrary to an EU treaty, and it was struck down. So there are different ways of achieving outcomes, but the reason I bring that up is that there's a slow realization that these changes 20 something years ago have long consequence and have embedded certain political viewpoints. And when you've got very difficult issues, as we have on how do we deal with the migration crisis, Parliament finds it difficult to deal with, in part because we are no longer dealing with Parliament as the sole giver of our laws.
In other words, the judges are making law, and in a fashion which I mean, it's been done before, James. I mean, you've been citing some legal history. Strikingly, before one of the great events that you mentioned, that's to say, the Bill of Rights and the Glorious Revolution of 1688-89, judges had been highly political.
Yes.
There was Judge Jeffreys. There was the deliberate use of the law to try to enable Roman Catholics to hold public office, the deliberate use of the law to enable the king to take over the army and pack it with Roman Catholic officers and so on. And all of that is deliberately overthrown in 1688-89, and moreover, and this should be a little warning, I don't want to be too unkind to your distinguished colleagues, but it is worth remembering that Judge Jeffreys was arrested and put in the Tower, and if he had not died, would certainly have been executed for his role in challenging the will of Parliament and using the law against Parliament. And I found this discussion absolutely fascinating, James, because it seems to me almost unprompted, you've been underscoring points that I've now been making for the last 2.5 years, which is under Blair, there was in fact a slow burn French Revolution that I call it the remedy that I propose for it is a Great Repeal, and that's to say an undoing of all Blair's constitutional legislation and a reinstatement of the position of about 1997, because it's perfectly clear Blair profoundly mistrusted Parliament, mistrusted anybody who answered directly to the popular vote, and was determined instead to send power. We've talked extensively about how it was diverted to lawyers in a fashion wholly alien to the traditional relationship between law and justice, law, justice, and politics in Britain, and also, of course, in another direction, which thank God we haven't had to talk about, to expert committees, the extraordinary proliferation of quangos and whatever that control so much of our public life. And in between, there are people like you still trying to swim, still trying to do traditional justice, and having the entire machinery of the state turned against you as you try and rescue a Chagosian bus driver, was it?
Yes, I mean,
the little man that the Labour Party, was supposed to be set up to protect, and the little man is being squashed.
yes, I mean, we had about 6 government lawyers in the courtroom on Tuesday. I've seen at least 8 different government lawyer names. Really, it's just 2 lawyers on our side.
So what kind of costs are they running up?
Well, in court on Tuesday, they had given us a statement saying that they'd spent about £20,000 on the primary preparation, but they said that wasn't all of it. They'd forgotten to give us it all. So they asked the judge that they could sort of put in further cost submissions when we get the decision. So if the decision goes against us, somewhere over £20,000 will have been spent against my clients, and they will want all that money back, and we will have a problem. And of course, you have to plan as a lawyer for worst case scenario. So whilst I hope we might win and we'll get a good result and then I don't need to worry as much, if we don't win, the problem is this is the last chance for these people to establish some rights. And even if the islands are still transferred, one of the things that we're trying to achieve is not dissimilar to what was done for the benefit of people in Hong Kong prior to 1997, was the handover, or 98? I'm suddenly...
Rights of resettlement.
Yes, and on Tuesday, the government's leading lawyer said it effectively. Oh, you just don't do that. If you're planning to transfer sovereignty, you absolutely can't embed rights of people. But we did it for Hong Kong. Why aren't we doing it for these people who actually, there's a accepted history in judgments, in government statements, that they were treated very poorly when they were sort of dumped on the shores of Mauritius in the past.
James, let's leave it there. But you presented, I think, a very moving case and an illustration of the actual contempt for people which a government that claims to rule on behalf of the people has, and a contempt for law in a proper sense of the word that a government of lawyers has. Could you just tell anybody watching this show who shares my feelings as to the outrage where they should donate and how?
Oh, certainly. Well, there is a couple of crowdfunders that were set up to try and raise some money to support these claims. If you look for Chagos and crowdfunder, they're pretty easy to find through search engines. And I hope we don't need it, but we probably will need it to fund the case forward if we have to make further appeals.
James, thank you very much. What I'm going to do is to ask my brilliant producer actually to put all that up as a pinned note at the end of our broadcast. And thank you very much also for daring to wander a bit. It was very courageous of you.
Pleasure.
And I hope it won't damage your career too much.
Thank you very much. Nice to talk to you.
A real pleasure.